Good afternoon, everyone. I'll let the record show that we have a quorum present, so we'll call the public hearings this afternoon to order. And we're continuing our public hearings on the fighting corruption in the Cayman Islands. And this afternoon we will have two witnesses, Mr. Robert Berry, who is the director of the Cayman Islands Financial Reporting Authority, and Mr. Richard Coles, who's chairman of the Anti-Corruption Commission Board. We had scheduled Miss Rosa Whitaker-Miles, but unfortunately she had an emergency. She had to leave the island yesterday. So we will reschedule her for another date, and we may take the opportunity, pending approval from the whole committee, to call somebody from planning, since we have them as an identified entity in the report. So if I could ask the page to bring in Mr. Berry, please.
I swear by Almighty God that the evidence I shall give to this honorable legislative assembly shall be the truth, the whole truth, and nothing but the truth.
Thank you, sir. Hello, Mr. Berry, and thanks for coming. You will have been informed that we are doing public hearings on fighting corruption in the Cayman Islands, and we invited you as the director of the Cayman Islands Financial Reporting Authority. And the only rule we have basically is when you answer the first question, just identify yourself by your full name and your title for the records, okay? So, Mr. Chris.
Good afternoon, everyone, and thank you, Mr. Chairman. Through you to the witness, Mr. Berry, first of all, welcome. Glad to be here. The purpose of this hearing that we're looking at, as the chairman alluded to much earlier, is we're looking at the Auditor General recently did a report on fighting corruption in the Cayman Islands. And one of the things that we want to, well, first of all, hope that these hearings will at least highlight to the general public that this is something that we look at and we consider very serious, but also at the same time use this opportunity to inform, educate, and enlighten the public with regards to the steps and the different tools that we have, both from a prevention standpoint and also from an investigative standpoint in terms of dealing with corruption. Your area of the Financial Reporting Authority is one such area that is used also in terms of combating. And what we'd like to do is just, for the very first question, just explain to the general public, the role of the FRA and what it is that it does and how it works with the other bodies in terms of fighting corruption in the Cayman Islands. Thank you.
Thank you. Good afternoon, Mr. Chair. My name is Robert James Berry. I'm the director of the Financial Reporting Authority. Through you, Mr. Chair, thank you for the question. The FRA is the agency responsible primarily for receiving, requesting, analyzing, and disseminating information regarding proceeds of criminal conduct or suspicion of proceeds of criminal conduct. In recent times, we've also been assigned the responsibility for ensuring that targeted financial sanctions with regard to terrorism, terrorist financing, proliferation financing are implemented in the Cayman Islands. To speak a bit to how the FRA plays its role in the fight against corruption and any other financial crime or criminal conduct generally, there's an obligation under the Proceeds of Crime Law for persons to file what we call suspicious activity reports, or SARs, with the Financial Reporting Authority where they have suspicion of criminal conduct, and that would include corruption. Once received, those cases are reviewed by the director and by myself or my acting director, and assigned to an analyst for review and to make recommendations. Should we decide or come to the conclusion that there is suspicion of criminal conduct, we would onwardly disclose that to the relevant agency, whether it be local law enforcement, being RCIPs, Immigration, Customs, the ACC, or to a competent body such as SEMA or DCI, who has responsibility for AML supervision, for them to take the appropriate action. We also have the powers under the POCL, or the Proceeds of Crime Law, sorry, to make disseminations to overseas FIUs where we have suspicion of criminal conduct. In addition to the threshold of suspicion of criminal conduct, there's a new provision in the Proceeds of Crime Law under Section 42CA, I believe, that would enable the FRA to disclose information to any local competent authority, whether it be law enforcement or a supervisor, even without the threshold of suspicion of criminal conduct. So if we form the view that the information will be relevant for them and material to them performing their functions, there is that provision that we can disclose it spontaneously or upon request. And I think that's the key way where we're a conduit through which information flows and is disseminated to the relevant parties.
Thank you very much, Mr. Berry. From your experience generally, and just looking back at the report, and I want to say for the record that this has been one entity that has consistently gotten the reports to the Legislative Assembly on time. And the two reports I'll be referring to is the annual report you did in 2016-2017, and also the interim report that you did from the 1st of July to the 31st of December 2017 to bring your reporting in line with the government financial year. So well done on that one. I think that was actually quite proactive. One of the things I noticed that you had mentioned is on the interim report that the FRA closed 42 of the 563 new cases. And I know, and the report is available online in terms of the public and everything else. What I'm curious about is, generally speaking, like, what will normally be most of the delays in terms of some of the stuff that is being reported? And from your experience, what are generally most of the stuff that are reported to the FRA? Thanks.
Mr. Chair, through you, thank you for the question. The delay in processing cases submitted to us, there's been a significant increase in the number of reports filed with the FRA. So if we were to go back a couple of years, in a financial reporting period, we were receiving around 600 SARs. In the last 2 years, particularly if you look at calendar year 2017 and calendar year 2018, and our 2018 report is in progress, because we do, as you said, we are an agency that we do meet our deadline of 3 months after the year end. There's been a significant increase in SARs, so we're now, I think in 2018, we received 938, which is pretty much a 50% increase over kind of the running average for the last few years. We did hire additional staff last year, and that made a significant improvement in the number of cases we analyzed and closed. Also in that 6-month period, it's not an excuse, but we were heavily involved in finalizing and preparing for the mutual evaluation report plenary in Barbados. We track our cases, and we've set timelines, obviously, as targets for us to achieve with the current in the current environment, we are struggling to do that. And as you said, all the information's in the annual reports. We are very transparent in the number of cases we receive, what we analyze, what we close, and therefore what's pending.
In terms of resources, because one of the things, and I think the public and everyone would appreciate, is that the financial services industry is our golden egg. And I think it's important for the public to realize, and I don't know if it's a number that you have, is that even though 600 or 900 cases may be reported, if we were to look at the number of transactions that we do annually in the Cayman Islands, I would probably say that they're number in the millions. So to have 900 suspicious activities, I don't want someone in the public thinking that 900 is a large number when you're looking at millions of transactions per year that is actually being conducted by these financial entities. So I just want to put that out there. One of the things that you had mentioned was in terms of struggling with resources. And the question is, do you have sufficient resources, you believe, in which to meet the mandate or the mission of the FRA?
Mr. Chair, through you, thank you for the question. We've recently undertaken an assessment of our resource needs, including both human and capital in terms of IT infrastructure. And we've concluded that we currently do not have the necessary resources to meet the mandate in the sense of the timeliness of what we would like to be achieving. And what we have done is prepared the necessary paper through our acting chief officer and the AG, the Attorney General, sorry, since there's the Auditor General. So I'll be careful then. Through the Honorable AG to seek supplemental funding in the this year in 2019 for additional staff, which we believe would put us in a place where anticipating that there could be more growth in the number of SARS files as a result of recent legislative changes in the anti-money laundering regs with the appointment of a money laundering reporting officer to each Cayman Islands fund. We've factored that in, and we've made the necessary requests for additional staff that we think will help us keep pace with what's coming in, but also to have some capacity to chip away at the pending cases that exist at this point in time.
Thank you very much. One of the things I've noticed from going through the annual report is that from when the FRA started, well, from being a unit within the police force to bit by bit is gradual evolution, which I guess goes again to show the growth of what it is that we're doing. In your experience and in your opinion, in terms of the legal framework that we have right now, do you see that something being adequate, or do you think that this is something that there are other laws we need to be looking at changing? Because I mean, we do have some laws on the book that are even 40 years old, not like in this case, but in terms of laws that you think that we need to update, and then more importantly, other areas that you think may be coming on the horizon that we should be looking at, that we think is a potential area that may be of a risk to the islands.
Mr. Chair, through you, thank you again. That's a very good question. I think the current legislative framework with regard to the operation of a financial intelligence unit, the FRA, I think our legislation is well placed and is up to date. As a result of the CFAT of mutual evaluation, we obviously undertook a very thorough review of the current legislative framework to ensure that the jurisdiction, and in particular the FRA, complies with the international standards with regard to being an FIU. So the proceeds of crime law, we have an all crimes approach, so there aren't specific predicate offenses that you file on. It's suspicion of any criminal conduct. It's usually in a financial context, albeit, but the responsibility now lies on everybody. So any person could file a SAR. I mean, predominantly they come from the financial services industry through the money laundering reporting offices for those entities. The DNFBPs, the designated non-financial businesses or professions, are also caught. So we have a broad spectrum of which people are obliged to file suspicious activity reports. The FRA has the powers to request any information it deems necessary to assist in analyzing those cases, and it has the powers to then disseminate to the appropriate parties. So from that point of view, I think the legislative framework for the operation of the FRA is very sound. There are other pieces of legislation that have reporting requirements, obviously. Given the context we're in, under the anti-corruption law, there are separate reporting obligations specific to an offense of corruption. It could be that someone would file the same information with the FRA, and obviously if they did that, we would process that, and if it's obviously local corruption, that would be an offense under the anti-corruption law. The ACC would be the appropriate body that we would disseminate that to. From my point of view, based on the general knowledge I have of the operations of some of the other competent authorities, I feel the legislative framework is quite up to date and more than adequate. I base that on the recent mirror that we went through and my general understanding of what I've read and seen from the other competent authorities.
Thank you. One of the things I remember going back to the time where I think it was maybe around Christmas when we had the issue with the money transfer and the whole Western Union and the whole 9 yards. One of the things that jumped out to me is that about more than 2 years prior to that incident, the U.S. Department of Justice had launched something called Operation Choke Point, which basically targeted the money transfer business, the pawn shops, people who sell guns and those little kind of stores, basically cash-heavy business. And of course, 2 years later, by the time it arrived, with all correspondent banking issues and the whole 9 yards, and I was a little bit surprised that that whole thing had caught the government and the people that came out by surprise. But within the industry, we knew that this was already an issue. And one of the things that I guess we want to make sure of is that we are still being forward-looking, because at the end of the day, we have a tendency sometimes to be more reactive as opposed to proactive. So with that said, what we're looking for is, just about every year that I can remember, we have had some adjustment to some law coming out with some new thing within the financial services industry. I mean, where do you see as being the next issue? Because one of the things is that they keep moving the bar every single time. And what I guess surprises me and many people in the public is we can't seem to be ahead of the bar. We're always like playing catch up. So the question is where do you see the opportunity for us to be ahead of what is coming on, as opposed to, again, waiting on some, I guess, global group to say, okay, fine, this is it, let's go move to this. Where are the opportunities for us to be ahead of the curve?
Mr. Chair, through you, that's a tough one for me to answer, to be honest. I quite honestly, I can't think of an area to get ahead of. I know of one that I think we're already behind on, that I know there's already discussions ongoing, and it's with regard to crypto assets. Some people still refer to it as cryptocurrencies, although there's been recent discussions that they're not really functioning as a currency. So I think crypto assets, currencies is an area, and the regulation of them. Again, I think that's more of a supervisory issue in terms of how to regulate entities operating in that space. But obviously, from my point of view, I think they would already be caught in terms of reporting obligations of suspicious activity, because they'd be engaging in relevant financial business, and so the anti-money laundering regulations and the provisions on the proceeds of crime would apply to them. Mr. Chair, and to the member, I can't really think of an area to answer.
No, that's fine, because actually your answer actually kind of brought out the point in which I was looking at in terms of regulation, because you report on what it is that we regulate, correct? In a nutshell.
Mr. Chair, I report on suspicious activities that are filed with the FRA, predominantly coming from the regulated financial sector or DNFBP sector.
Yeah, thanks. So, okay, so in a nutshell then, like you said, okay, if we look at a suspicious activity, then, I mean, that in itself is a very broad area. But for us, the main thing is we're looking back at the numbers where something is suspicious, because I know it's like a lot of them, like of the 500-600 that used to be, like 100 of them would be closed where what somebody would consider suspicious, and which is fine, because not many people are trained to identify what is suspicious versus like what would the criteria be used that someone would send to you that you would say this is maybe suspicious to the person but not really suspicious to us. It would be a normal transaction.
Mr. Chair, through you, there are instances where people, they're commonly referred to as defensive filings. So there's that arena where people, and I think if I was an MLRO, I would do the same thing, where if there's something unusual and they do, they look into it further and then arrive at, well, no, I think this is suspicious. They will file that with us, and because we have access to maybe broader information, so something that might look suspicious to them based on information we might have access to, we would say, well, no, that's actually quite fine based on the analysis we've done. The source of funds checks out, or whatever else it may be. With regard, I mean, no further action is a case where, based on all the information in front of us and the analysis we've done, we don't think that we've met the threshold for suspicion of criminal conduct, and that's not a very high threshold, in my opinion. So there's, when you start to look at the annual reports, and indeed when the 2018 comes out, you're going to see a lot of disclosures to law enforcement, competent authorities, overseas FIUs. Yes, you're still going to always have that percentage that get filed NFA. One of the things, or no further action, one of the things, and it's imperative on the FRA to do, is to do outreach and to better inform people and provide examples of what is suspicious activity. It's a very subjective determination, so two people may look at the same set of facts, and one may say no and one may say yes. But by and large, we don't want industry just filing for the sake of filing, and that's actually an area of improvement where if we move forward with the new IT infrastructure, one of the things we're going to do in that is mandate that whoever's filing the SAR must identify a predicate or some kind of offense that they're suspicious of, so that it forces them to before they send it in and sign it off, that, you know, it's not just a general suspicion. I'm suspicious that this is fraud, or this is layering and money laundering type thing. So
just one last question. I noticed in the 2016-2017 report that you, when you're giving a breakdown, and again, like I said, it's a well-completed report. It did provide a lot of information. One thing I was curious about from reading the report is where it says 4 of 12 cases carried over from 2013, 2014. I was just curious, not to get into the details of the cases, but like those 4 cases going back so far, what would be the hold up of why those cases would be outstanding for quite some time? Is it a legal issue or treaty issue, or?
Mr. Chair, through you, I think it's just a pull on priorities. So what we try to do is take a balanced approach to try and keep the current and still chip away, and obviously make a big push to eliminate those older ones. I'd have to look at them specifically, but I suspect that the most honest answer I could give is that it's just a pending matter that something else took a priority over.
I just want to make sure it wasn't in a case where it was being held up in a legal case or somebody's waiting to be prosecuted in some country. Well, thanks very much, Mr. Chairman.
Thank you, Mr. Chairman, and certainly through you. First of all, I want to echo the welcome of the witness. Thank him for being with us this afternoon. I think the benefit of these hearings is, in many cases, it allows the public an opportunity to learn a bit more about the mechanisms presently in place that help protect against things like the broader issue of corruption, criminal conduct, money laundering, etc. As such, I want to take us back to some of your earlier testimony, to some of the questions from my colleague, the member from Bordentown West, and talk a bit about the operation of the FRA in its, and forgive me, this is my definition, in its gatekeeper capacity, one way or the other. You mentioned having, I think I heard you correctly, 600 SARS or suspicious activity reports on an annual basis. Is that a correct number? Did I hear that correct? 900, now it's increased to 900 last year. Well, to my point, in your professional experience, what is driving this increase in SARS on an annual basis?
Mr. Chair, through you, this is usually a very popular question to which I would it's very hard to say in terms of I think a big driver right now is that there is now a new requirement for each Cayman Islands fund to have an appointed MLRO, and so I think we're already seeing cases where 2 different people are filing on the same thing because the MLRO of an entity that provides a service to, say, the fund, and now the appointed MLRO, they're seeing the same information. And legally speaking, they have an obligation under the Proceeds of Crime law to file. I think other things that could be driving it is that, I mean, like many other things, there could be more adverse information coming out in terms of, I mean, adverse media is a major trigger for a SAR filing. So a client that until the news breaks that he's been indicted in New York for securities fraud, the service provider might not have been aware of any such activity taking place, but that adverse media would trigger them to review the client relationship. And I would expect to file a SAR. So I think over the last couple of years, you've also seen an increase in governments and agencies worldwide cracking down on fraud, corruption, those types of things. So I think those are all drivers.
Thank you for that response, Mr. Chairman, through you. Certainly, if I can draw a few conclusions, perhaps it would be safe to say that it is a direct result of the robust avenues in which financial services industry participants have in terms of the country's laws, regulations, and otherwise, that they feel comfortable. And certainly it is made easier in which they can make these reports on a daily or annual basis. And that otherwise suggests to me that in one way or the other that the industry as a whole is following the rule of law. But again, that would be my assumption based on your response. I wonder if we could talk nuts and bolts for a minute. What is the ratio following investigation of these suspicious activity reports that are found to be either legitimate or meeting the threshold requiring further action versus those that might be defined as spurious, false, or I think as you put it, filed as NFA, no further action presumably required? What is the ratio between those that are successful passing the bar versus those that go to file 13?
Mr. Chair, through you, I'd have to quickly look at some stats, but I would like to say that even if something's filed NFA, it's still recorded as intelligence, because time and time again, something filed as NFA 3 or 4 years later, when another filing comes in, it then takes it up to the next level in terms of additional information that then you go back and look at that and go, okay, 4 years ago that was filed, no further action, but given these developments, it's quite often that that report would then get attached to, or the information in that report would be included in any disclosure. I'd have to quickly look at the statistics, but in each of the annual reports, it does give a breakdown of what's been filed, no further action, and then detail in quite explicit detail. I mean, it goes line item by line item, disclosed to RCIPs, disclosed to RCIPs and SEMA, disclosed to RCIPs, SEMA and immigration, disclosed to customs and immigration. So it is quite specific. I'd have to take a quick look if...
Mr. Chairman, sorry, through you, forgive me, if the information that I seek is readily available, which I suspect would be through the annual reports, there's no need for you to quote it. Perhaps my colleague has a copy of it available and maybe he can answer the question. I need not have you search up for that answer, which I can obviously ultimately find for myself. If I could go back to one final question as it relates to the ability of the FRA to fulfill its remit. You mentioned not having adequate resources to meet the growing demands of the FRA. 600 SARs jumped to 900 SARs last year, presumably. The demands on your division as an intelligence unit are increasing. I wonder if you can expand on these lack of resources. Is this human capital that we're talking about, more staff, or is it broader technologies that perhaps can supplement the need for more human bodies? What is it?
Mr. Chair, through you, thank you for the question. It's both. The assessments we do, you basically max out the number of analysis that a person can do in the course of a year. Once you factor in, I mean, some cases are fairly simple and straightforward. Some cases are very complex and take more time. But ultimately, even if you just went with a general ratio of, okay, let's say a staff member will analyze and hopefully close 100 cases per year, there are persons who exceed that, so that's just a general benchmark. When you start to get into the numbers of 1,000, 1,200 SARs, a staffing complement of 6 or 7 people to do that, in addition to some of the other work that we need to do in terms of outreach, doing strategic analysis, and contributing in other ways to the fight against financial crime. We are ultimately spending all our time analyzing and trying to get cases analyzed and closed. So we are seeking, the request we're making for supplemental funding is for some additional staff. It's also for an IT system that would, one, facilitate electronic filing of SARs, which is a key feature that's necessary. It's been a complaint of the financial services industry for a long time, the whole manual delivery, either hand delivering it to the FRA or sending it in by fax. So we're exploring whatever system we get. It's going to allow for the electronic filing of suspicious activity reports in a secure manner. And we anticipate that e-filing, all the information in that will then automatically populate whatever database the information is stored in. Again, versus the manual system of having to populate it by retyping information that's already provided to you. The system will also need to have certain analytics that will enhance the manual analysis. So it will have features in terms of connections and relationships between parties and being able to map that out. Obviously, you know, you always hear pictures worth 1,000 words. Sometimes when you see it graphically or in a link chart rather than writing out names connected to entities. So there is that element of it as well. And so it's both, and I think whatever system we do get, I think there will be efficiencies realized in that compared to our current process. But given where the numbers are now, the human capacity to actually do the analysis and to type up the assessment done and the recommendations, there's a need for additional people.
So one final one. Sorry, RJ, and I hope you have, I don't know if you brought your reports with you. I just had one question that is curious, which would be on page 17 of your interim report and page 18 of your full annual report. Just in a nutshell, like, I couldn't help but notice that on the 2016-2017 report, where you were looking at comparison of monthly cases received, I noticed like in December 2015, you had roughly around 24, 25 cases. But then in December 2016, the number jumped to about maybe 210. And I noticed prior to that, the highest month, just looking at the 18-month period, would have been around 88, which would have been in November 2015. So November 2016. I know there's been a big spike. Now, I know my colleague from Prospect had raised the issue or asked a question in terms of like part of the reason for the jump, and I believe one answer that was probably omitted that could probably be used is also the increase in, I guess, public awareness or public knowledge in terms of these activities. And I don't have a problem with it jumping up, but if you kind of look at the graph by itself, you would have seen that, I mean, if the camera can zoom in, this green bar is just out there by itself. And the natural person would ask what really happened in December 2017 for it to have jumped above 200 and over 200 cases, when prior to that it has been maybe around 70 or 80 is the highest for any month looking at the period. Now, I know December is the end of the year, and normally auditors will come in like around January. So I don't know if it's a situation where people are getting together their end of year accounts and then realize that something was happening and say, you know, let me file these off before the auditors come in. I don't know, but it kind of really jumped out when over 200 in 1 month. Just curious, like what happened?
Mr. Chair, through you, what I can say about that, and we did make a comment in the report on it, was there was a one-off event that resulted in a spike. I really can't go into a lot of detail, but as a result of a one-off event that we don't anticipate will happen again. But we ourselves, we knew we'd have to at least put something in there to try and explain the spike, and as you said, it was a one-off event, and I think that's all I could really say about it.
But I just have one general question. One of the complaints of the international agencies that we have all these agreements with seems to be that we don't get enough successful prosecutions in court. So therefore, our enforcement always seems to be questioned as to whether we might have the stuff on the books. We don't seem to be prosecuting enough people in banking and in the financial industry in the local environment to indicate that we are in fact serious about the crime.
Mr. Chair, that is a very accurate representation of the perception out there, and it's something that I think jurisdictionally we do need to look at further. From an FRA perspective, we're an administrative FIU, which means that we don't have investigative powers, so our role is receive, analyze, disseminate. We obviously work closely with law enforcement agencies, and one of the things we always strive for is to get feedback from the agencies we disseminate information to, in terms of how useful was it, how was it used, if it isn't useful, why wasn't it, is there additional information you'd need from us, and I think that is an area that...
Do you have a view or an opinion as to what we can do to make sure that more people get prosecuted by the prosecuting agencies so that our image is changed internationally?
I don't have a view as such, Mr. Chair. I think that each agency has to look at its role and take an honest look in the mirror as to whether it's discharging its functions, and it's not always easy to say, well, I'm resource short or whatever. And I think there's a certain diligence that's required to keep fighting the fight, so to speak. And again, for us, it's absolutely correct, because the international community, and even through the mayor process, is going to look at, okay, well, that's great, Mr. FRA. You analyzed this, you disseminated that, then what? And the use of financial intelligence is actually a big component of...
Is it a situation, would that situation be improved if your agency was given investigative powers and prosecutorial powers? I know that our Constitution says that the only person that can prosecute anybody for any crime in the Cayman Islands is the DPP. But one is beginning to get to the stage to believe that that's just far too much for any one agency to do. And maybe it's time to expand the prosecutorial function to some of these anti-corruption agencies in order to demonstrate to the international world that we are serious and we are in fact prosecuting people.
Mr. Chair, my view would be that I think the current strategy taken by the Cayman Islands in terms of having an administrative FIU is appropriate. It segregates duties, indeed, as a member of the Egmont community, over the last 2 or so years that I've been in the role, you've actually seen a number of FIUs move away from being a hybrid or a law enforcement to become an administrative. Now that doesn't mean that that's the way to go, but I think a lot of agencies are basically either at the point where they don't have the resources to do all of it, so breaking it up into different agencies works for them. I think the model we have here is workable, and personally I think is the right model. I think if you so for example, I'll be very candid, Mr. Chair, if it was a law enforcement FIU, I certainly wouldn't be the appropriate person to head it up, because I'm not a law enforcement officer. I know about doing investigations to a certain degree, but when you're conducting criminal investigations, it's in a whole different sphere. So I think both models can work, and I think what's most important is for all the agencies involved to be speaking to each other and be on the same page in terms of the priorities of certain matters, particularly because of the international scrutiny, as depending on what chart you look at, whether we're the 5th, 6th, 7th, whatever largest international financial center, there are higher expectations in terms of the flows through Cayman and the size of the financial industry here.
Even locally, it's not uncommon to hear comments from people that, well, I think it's public, but let's take the case of HSBC. The US government fined them, I think it was billions of dollars, or certainly hundreds of millions of dollars. We did nothing in Cayman other than close their doors and they are gone. Are we losing out, or is that part of the reason that we have this reputation that we're only pretending to do these things because we don't really do anything?
Mr. Chair, my response to that is in the HSBC matter, albeit the US did impose a significant fine of, I think, 1.9 billion, and I think it was a 5-year deferred prosecution agreement, and this is from memory, Mr. Chair. The one thing I will say about what Cayman did, I think Cayman was one of the only jurisdictions that actually revoked a banking license for that group.
You see, here is what the local community to say, yeah, we revoked the banking license, and all the people who were doing business with them lost out because they were shifted over to some other bank that they didn't know anybody in. But the country got no benefit. We should have got enough from them to pay off the national debt. I mean, every other jurisdiction that I believe that they had a problem with, because I think Mexico fined them substantial as well. But Cayman, they simply sold their business to some other bank or banks or other financial institutions at a profit and walked away from scot-free.
Mr. Chairman, I just want to add for the record, because I was employed at HSBC at the time that happened, and what I can say to you is that the Cayman government at the time did try to impose a fine on HSBC, and the problem was that the legislation actually limited the ability to do so. And I can say for a fact that the government did try to find a creative way, and it was blocked by one particular individual. I won't say who it is, but I can tell you for a fact. But that's a different story for a different time.
But getting back, this is what I'm saying. If we're not getting the results, if we can't demonstrate to the international world that we are prosecuting people and fine, is it because the legislation in these other agencies, and maybe you don't want to proffer a view on that, is it because the legislation in your agency is inadequate in these respects? And is that because there is some political lobby in the financial industry that is preventing the kind of legislation and the kind of teeth that we need to be actually put in place?
Mr. Chair, what I would say to that is that my opinion is that the proceeds of crime law and the relevant legislation in the Cayman Islands is certainly robust and appropriate for the operation of the FRA, and I think for the investigation and prosecution of criminal conduct. Anything outside of my remit, I don't think I'm the best person to speak to it, Mr. Chair.
Thank you very much. I know that one went a little bit off. Just one final question from me, Mr. Barron, and thanks thus far. One of the things that some people believe is that we sometimes report a little bit too much information. If you're going to see my website and you were to look at even the total deposit held by Class A and Class B banks, you would see that it's in excess of $700 billion. But if you were to really dig into that money, you'll realize that the bulk of them are in correspondent banks overseas in the very countries. But people would leave the impression as if though these monies are actually here. And one of the things that jumped out, so I say all of that to say, sometimes I think we put information out there that people are looking at internationally, and I think it gives our competitors and other people to look at us in a different light. And one of the things that jumped out from reading your reports is when I looked at the full 2016-2017 report, and just to kind of give an idea, and I choose Americans for a reason, and I'm reading from page 19, where we're talking about the cases that you guys you got, and I just want to read briefly. It says, the greatest number of subjects was classed as Caymanian. Of those 297, 64 were Caymanian nationals, natural persons in bracket, and 233 were legal entities established in the Cayman Islands. And this is the part now where I want to zero in. Then it goes on, it says, the United States provided the second largest number at 108, comprising 95 natural persons and 13 legal entities. And third went on to Ecuador. But then when I went to the interim report, just looking at the two, just to kind of give myself a kind of point of reference, and goes on in the interim report, it says the greatest number of subjects was classed as Caymanian. Of those 278, 50 were Caymanian, meaning that in terms of natural persons, it went from 64 down to 50. But then the part that grabs me is says, and the United States provided the second largest number at 249, comprising 241 natural persons. And what really jumped out to me is the United States number moving from 95 natural persons to 249 natural persons. And if I was a person in the US overseas looking at that, I'd be kind of wondering what it is that Americans are doing in Cayman, why their number moved from 95 to say 241. I mean, that's a substantial jump. Now, granted, it may just be cases being reported, but from that standpoint, just reading it in that context, you know what I mean? And of course, it could be a situation where 100 of them was really basically nothing, but the number just kind of jumped out. And these are the kind of stuff that some people may believe that the U.S. will go look at and say, wait a minute, what are American citizens doing in Cayman? Let us put some pressure, put something on the Cayman Islands, when in fact, it could have basically been nothing. So that's what I was trying to understand, like, what would have been driving the increase in the numbers from 95 to over 240?
Mr. Chair, through you, I don't think I can identify a specific driver. Again, what we ensure is that when we get the case, we, to the best of our ability, identify the predicate accurately and the subject accurately. And a report may have more than one subject. So if we think the report is primarily about a person or an entity from this domicile or that nationality, that's how it gets classified. And going back to, I think, the question that was posed about the numbers and what drives them, that was the activity during that period. And it could very well be that the next period, the number fluctuates back down. I think what the reports do show is that consistently, the Cayman Islands and the United States are, well, in the two reports you've looked at, they're 1, 2. And again, largely the Cayman is Cayman domiciled entities as opposed to natural persons.
Yeah, the thing I'm trying to get at is, in terms of this reporting and maybe just a writing style, but if there's a sentence that can come after it that basically says, of this 241, 150 proved to be nothing. But I mean, just leaving something like that by itself, I mean, like I said, I'm reading it and it leaving me to guess, whoa, like, somebody's doing something, but and what we're basically trying to avoid is people jumping to the wrong conclusion, because we already have enough people overseas that's kind of looking at us sideways, I mean, in terms of kind of adding more meat around it, so at least not to give the impression as if though, there's 241 Americans as opposed to 95 the previous year. So just more stuff like that, really. And like I said, it's just a matter of style and something to consider for the 2018 report. Thanks.
Mr. Chair, through you, thank you for that suggestion. That's something we'll go away and review and prepare in the 2018 to see if we can provide additional wording to make it clearer.
Mr. Barrett, thank you very much, sir. We appreciate the time you gave us, and we certainly will take into consideration your answers in our report. Thank you very much for coming, sir.
I just want to add one more thing. I know, RJ, that you have a very limited team, and like I said, I went back and looked at your website and look at what it is that you guys are doing, and you guys are doing some good work over there, some great work over there with limited resources. And I just want to say on behalf of my colleagues, thanks, keep it up. You do put a lot of information out there, which is good. For us, it's good, but I just want to make sure it's not too good for our competitors or other people looking in. But, just well done to you guys, and just keep it up. It's really good work.
Mr. Chair, through you, I want to thank you and the members for the discussion and for the positive feedback and encouragement. I, too, want to thank the committee for the opportunity to be here, and in particular, to talk a bit about what the FRA does. It's actually, sometimes we take it for granted because we primarily deal with the financial services industry, and they have a pretty good working understanding of what we do. But sometimes when I run into someone on the street and they say, hey, RJ, how are you? What do you do? I'm the director of the FRA. And they go, is that part of SEMA? Or they honestly don't know. And one of the things that's actually been suggested to us is that we do a more general outreach to the general public on what we do. So I think this is very useful in that regard. So thank you again for the opportunity to be here.
Can we do that now?
Yes, sir.
I swear by Almighty God that the evidence I shall give to this honourable legislative assembly shall be the truth, the whole truth, and nothing but the truth.
Thank you, sir.
You're welcome.
This person's back.
It is.
But it's a better set of circumstances.
It
So
feels kind of
we're
nice.
we're much friendlier than the General Assembly. But just to thank you, Mr. Coles, for taking the time to come and answer some questions for us. As you will have been made aware, we are dealing with fighting corruption in the Cayman Islands, and as chairman of the ACC, the Anti-Corruption Commission, we rely heavily on you to be a very integral and important part of that fight against corruption. I guess the first question is probably, as chairman, are you satisfied that the legislation in its present format is achieving the goals that the anti-corruption was set out to do?
Yes, Mr. Chairman, I think in broad terms it is. There has been some amendments to the law, as I think you would be aware, fairly recently, and there will be some further suggestions that we're going to bring forward. But they are really sort of relatively minor things that arise because, as the law was, Royal Cayman Islands police officers were investigating corruption offences, whereas now we have investigators as part of the ACC, and some of the powers have not transferred as well as they should have done. So we need to sort of rectify that. But they're sort of technical matters rather than anything that goes to the general heart of the law.
I forgot to ask you, sir, when you answer the next question, just identify yourself by your full name and your role, just for the records of the House.
I'm Richard Coles, and I'm the chairman of the Anti-Corruption Commission.
How do you think the role of the ACC has changed since its inception? Are you satisfied that the ACC is being able to adjust to a changing role in our society?
I believe it has. Of course, when it was first formed back in 2010, it was a slightly different animal to what it is now. And the composition of the commission itself was various public officers plus a couple of private citizens, and the chairman was the Commissioner of Police, whereas now it has no public officers on it. We are all private citizens.
Yeah, I think that's a big improvement, actually. But the other thing, are you getting the kind of support from the other anti-corruption agencies in a collaborative way to do your job?
Yes, I believe we are. We've entered into memorandum of understanding with most of those agencies, and in fact I think all of them now. Maybe the only one we're still waiting to have an MOU with is the prison department, but otherwise we have MOU with them all. I think they're working well, and as far as I'm aware, we get good cooperation both ways with those agencies.
I know that we have, as you said, recently we've added an investigative arm. Do you believe that the Anti-Corruption Commission is growing to the fact where you may want to be able to not only investigate but prosecute?
Well, we've always had an investigating capability, but it used to be handled by RCIP's officers, whereas now we have our own, although all of our investigators have experience as senior police officers before joining us, so they're all experienced investigators. As to prosecuting, well, of course, in Cayman, the DPP has that right.
Constitutionally, I know.
Yeah, and so, and I don't have a problem with that. I think in some ways it's not a bad thing for an investigator, when we've completed our investigation, to have an independent third party assess it before it actually goes to court. I think there's something to be said for that.
Yeah. But the reason I asked that question is because there are some anti-corruption commission agencies. The one that is often quoted to me is Hong Kong as having their own prosecutorial arm, and people will often wonder why we don't have it here. And I think your answer is proper and quite good.
Yes, I mean, the Hong Kong Commission is very well established and has been very effective. And in fact, when I was in Hong Kong a couple of years ago, I had the opportunity to meet with one of their deputies and was very well received there. And they were very interested to hear about what we did in Cayman and quite surprised at the lengths we had gone to here. Because as you were well aware, Mr. Chairman, we don't always get the press that we deserve,
No.
not internationally, and so they were very happy to hear that. But they are a massive organization, and they have considerable number of staff. But yes, they go right the way through to prosecute. I'm not saying that couldn't happen here, but constitutionally it couldn't happen at the moment.
Under the present constitution. But are you as chairman, in your assessment of the resources that the administrative arm has, are you satisfied that you have adequate resources to fulfill the role of the legislation?
That's a tough question, Mr. Chairman. I suppose I would say we never have enough resources, really. But, and the truth is, and I'm happy to admit this, that we do have to prioritize cases. We just cannot proceed with every matter simultaneously. And so we prioritize and reprioritize continually. And yes, if we had more resources, we could proceed with more cases at the same time. So I would never turn that down. And if we continue to receive reports at the rate we are doing, and then I think we will be looking for more resources, both in terms of qualified, trained investigators, and we would like to see another trainee investigator. We have one who's just joined us last year, a Caymanian, and in fact I can say now we had some exceedingly good applications, and it was difficult to get to the one who was eventually chosen to join us. So there is no shortage of individuals out there who would like to join and who are capable of joining. So that would, I think, be a good thing too.
Do you believe that enough people are aware that they themselves are committing a crime if they are aware of the possibility of corruption and they don't report it to your agency?
We certainly make that clear on our website, and that is true. There is an onus on members of the public and indeed public officers to report matters that they are aware of. But I have to say we do have, in my opinion, very good cooperation from the public. I can't really speak before this present commission was formed in 2016, but I believe that we do enjoy a high level of confidence of the public in Cayman, and that's demonstrated by the sheer variety of reports from the whole spectrum of individuals in Cayman. So, no, I have no complaints about people reporting. I think they are confident. I like to think so in what we do, and I think they are also very happy that we keep these matters strictly confidential, and so you do not have to think when you make a report to the ACC you're going to find it in the Compass the next day.
Yeah, that's very important. I wish I could say the same about the police and the immigration department. Having been exposed by both, but so are you confident, or can you opine on whether the increased number of fraud cases is as a result of more fraud in a society, or people just getting more comfortable with reporting it?
Difficult one to answer. There's certainly, we're getting more reports, and that I think is the key to it, really. The key is I wouldn't say we rely entirely on reports, because we're perfectly capable of initiating investigations ourselves, but we have sufficient reports coming to us that we really don't have, I suppose, the capability at the moment to initiate our own investigations if we chose to do so, because we have more than enough reports coming in, and effective reports too.
Thank you very much, Mr. Chairman. Speaking of reports, Mr. Coles, first of all, I just want to thank you guys for the report that you guys did publish. It's an ACC annual report, 1st of July 2017 to the 30th of June 2018. And yep. It's actually a pretty good report, if I must say so. It was actually quite informative. One of the things I know you probably didn't walk with a copy, but that's fine. One of the things that jumped out at me on the report was we're under the section Control, Oversight, and Policy Directions, where it said, oh, you did walk with it?
Yeah, I
perfect.
have a copy with me. Yep.
Good. On page 4, don't worry, well, that's good, it'll be easier, where it says the governor has broad powers of oversight over the work of the commission and may give to the commission direction as to the policy to be followed in the exercise and performance of its functions. Then it goes on to says, to date, the governor has not issued any such directions. The commission may, after consultation with the director of public prosecution, issues guidelines setting out the forms and procedures of making a report of a corruption offense and the operational procedures in connection with disclosures made to the commission. With that said, sir, I'm just curious in terms of, are there any limitations of you found, or in your opinion, where even though that no directions have been issued, is it something that the commission needs, or I'm just kind of curious as to why it was included in the report. Was it a silent cry for help, or I don't know, I'm just curious.
No, it was included because that's what the anti-corruption law says.
Mm-hmm.
And it's true to say we haven't received any directions from any of the governors since the commission was formed. Having said that, I think it also says in the report that the chairman and myself, I meet fairly regularly with the governor, not on a sort of monthly or quarterly basis, but as and when required, and brief him or her on what we are doing. And if there's anything that obviously the governor wishes to raise with me, that's the time to do it. But we haven't received any formal policy directions, not to date anyway.
Okay, thank you very much. Just one of the things I also want to touch on, which starts on page 12, is section 5, topical issues. And I noticed that there were some listed, and again, I guess I really have to commend you guys for the report that you guys have put out there. I think it was it's really good. It was quite informative. One of the things that jumped out was on page 14. It says meeting with the deputy governor, and the report says the chairman met with deputy governor to discuss wider issues which affect both the civil service broadly and the work of the commission directly. It was agreed that the manager and senior investigator would meet with the deputy governor and the senior management team to further these discussions. However, due to various scheduling conflicts, the meeting has not yet been rescheduled. Well, I recognize that this report was up to the 3rd of June 2018. I'm just curious that since the 1st of July or onwards, have you guys had the meeting with the deputy governor with regards to the matters that you raised in this report?
Unfortunately not.
Quick one. All right, no problem. One of the other things that jumped out, also, is just touching on the media policy, where it just says the commission noted that there are numerous instances where the media references the wrong cases and or provides incorrect information in its reporting. The commission agreed it was difficult to make corrections to these reports due to the fact that they usually reference an ongoing investigation or a matter before the courts. The commission agreed that whilst the standard policy is that it will not comment or correct these reports, there will be exceptional circumstances in which the commission will make further information available. It goes on to says, The Commission issued on its website a media policy setting out the circumstances where the Commission would release information regarding persons who had been arrested and or charged. The chairman continues to be the official spokesperson. The single point of contact for members of the media is a manager who in turn will liaise with the chairman. Just out of curiosity, I mean, just looking at that issue itself, and I do recognize the sensitivity, and especially we in this house is mindful of commenting on anything before the courts. Have you guys found a workaround in which, within your policy, that would basically deal with that issue? That would also, because at the same time too, what we don't want is when you do have incorrect information in the media, on a small island, the possibility of even probably tainting a jury pool and everything else. But have you guys found a workaround that will allow you guys to continue doing what you're doing, while at the same time ensuring that to some extent the wrong information does not continue to be out there in the public domain?
Yes, that's a good question, and I suppose it's a balancing act, really. We don't give details when an arrest is made. We do not name names at that point, but of course the press are aware of it, and we make a press release, and we give very limited information that individuals have been arrested and searches carried out under a search warrant. But we do not name names, and we do not give details of the case. Difficult to prevent the media coming to their own conclusions, which they very often do, and unfortunately they're very often wrong. They sort of get part of
that, sir.
They get part of the truth, but not all the truth, and then they print it, you know. And the only thing we look at, the sort of plus on that, is that when the press continually report something that is wrong, we know that the ACC is not leaking. But in terms of correcting it, that is very difficult. I mean, even when the press will sometimes call us and say, we hear that you might be investigating such and such. Can you confirm whether you are or whether you're not? And we have a policy of neither confirming nor denying these sort of things, because once you say, no, you're wrong on that one, you'll get questions every day saying, well, how about this one? Until eventually get one where you say, we can't deny that. Oh, so that means you are doing that one then, are you? It's very difficult to... So we've made the policy, that's our policy with the media, not to be obstructive, but so that we don't find that people are getting named before they've ever had a chance to really see what's in front of them. But if there was something outrageous printed, we would try and find a way to correct that without jeopardizing or prejudicing what we're doing. But we understand the needs of the press to inform the public, but we have to protect the investigation that we're doing, and indeed protect what could turn out to be innocent people who are never charged from having their names splashed around the media.
One of the things, thank you very much for that, Mr. Coles. One of the things that we had kind of highlighted from yesterday with regards to the public as a whole is that the Auditor General report, Fighting Corruption in the Cayman Islands, was more meant to kind of inform, educate, and enlighten the public in terms of what it is that we're doing to prevent, investigate, and if need be, prosecute corrupted individuals. And one of the things that we were hoping to get from this session, particularly for the public, is to kind of let them know what it is that we're doing. So that's the reason why we're kind of putting these things on the issues, because we know the media do report what goes on in this committee, and at least put it out there in the public that this is still an issue for us, and it is something that we take seriously and something that we're looking at. With that said, I noticed that within your report, you had listed out several agencies that you guys were looking to meet with and work with in order, I guess, to facilitate better relationships and kind of, I guess, to expand, what it is in terms of having, I guess, multinational agencies work together to fight corruption, which I think is a good thing. And I know it's like you listed the major organized crime and anti-corruption agency in Jamaica. and also the Miami National Crime Agency and the Commonwealth Caribbean, just out of curiosity, and for the listening public, can you just give us a brief idea in terms of how those discussions went and what it is that we were looking to achieve in terms of broad outcomes that we're looking for in terms of having those discussions?
No, with pleasure. Well, first of all, let me say that I value the opportunity of appearing before the Accounts Committee today to do that very thing, make more public the work that we do, and I hope it is reported, of course. Now, as far as those organizations are concerned, I mean, geographically, they're very close to us, and we have in the past often benefited from cooperation with them. But I thought it would be helpful, certainly in terms of the major organized crime agency in Jamaica, if we introduced ourselves and let them know who we were. And I've personally met with the head of that organization. So I think that cooperation is enhanced if individuals actually know each other and have met. And we certainly have good cooperation from them, because there's often areas where the Jamaican authorities can assist us. And within Miami, their net spreads way beyond Miami into the US. And so they can be very helpful to us, even if it doesn't necessarily relate to Miami itself. They can facilitate our inquiries into other areas of the United States. And I'm pleased to say that in both cases, well, in the case of the agency in Miami, they came down here. In the case of the Jamaican authority, I was actually in Jamaica, and so I took the opportunity of meeting with them.
Thank you very much. In terms of the big picture, what do you think it is that, I guess we, and when I say we, I'm talking not just people in the members of this legislative assembly, but the public as a whole, because this is an important issue in any democratic society to ensure that we have prosperity. What do you think it is that the public needs to be more aware of, or what is it that the public can do to better fight better fight corruption more, in order to make sure that we stamp this order properly, deal with it here in the Cayman Islands?
Well, I think certainly keep on letting us have these reports when you feel that something is happening. But I think one of the areas that we have noticed in the various reports that we've received and the various matters that we've investigated is that generally these matters get reported and come to light at far too an advanced stage. Very often they come through the Office of the Auditor General when they've been doing an audit or internal audit. And many of these matters should be picked up a lot earlier than that. You might ask why they're not. And the Commission has given some thought to this. And I think part of the problem is that we have a lot of supervisory structure within the public service, but the supervision is not always being done. By that I mean that when superior officers are required to sign off, to use an expression, they're just signing off, and they're not actually probing into whether they should be signing off. And if more of that happened, these would get picked up earlier. So, I mean, no reflection on the Auditor General, but really it shouldn't be the Auditor General picking these things up. They should be picked up earlier. And I think if that happened, we would have these matters nipped in the bud much quicker. They wouldn't grow into what they sometimes do grow into, and maybe it would dissuade people a bit more from carrying out these activities.
Thank you, Mr. Chairman. Through you, first of all, I just want to welcome Mr. Coles, the witness, this afternoon. Thank you for appearing, and if I could just briefly continue with the rolling out of compliments that my colleague, the member from Boddentown West, started with. I think in this world of increasing number of fraud and corruption and the need to provide mechanisms, gatekeepers, to protect our economy and our way of life in the Cayman Islands. I think the public should be confident that the chairman of the Anti-Corruption Commission also is a former Attorney General of the Cayman Islands, so I would like to think that the Commission is in good hands.
Thank you.
I would like to take us back to the issue of adequate resourcing in terms of the Anti-Corruption Commission's remit and ability to perform its tasks. Also questions relating to, are you doing enough to just get by, or are you failing to meet your optimal potential as a commission? If I can do so by looking specifically at the Auditor General's report, paragraph 45, which is contained on page 20 of the report, states that the Anti-Corruption Commission staffing has increased significantly since 2015, from 1 investigator to 6 investigators in 2017. The Anti-Corruption Commission also acquires specialist expertise from outside the Cayman Islands to support some of its activities and investigations, but then the paragraph goes on to state that this reliance on others may affect time taken to carry out the investigations. My question, Mr. Coles, through you, Mr. Chairman, is one of outsourcing versus insourcing. You know, it's been stated numerous times that the Cayman Islands is a recognized leader in financial services, and as a result of that, we are also a leader in the mechanisms required to support that financial services industry. And by that I mean lawyers, accountants, forensic auditors, law enforcement professionals. So forgive my ignorance, but perhaps you can enlighten this committee as to what are the skill sets needed by the Anti-Corruption Commission to fulfill its remit that cannot be found within the Cayman Islands specifically.
Yes, thank you, Mr. Chairman, through you. It's true that there is expertise that we do not have within the Anti-Corruption Commission itself, and in some cases it's not available on island. And you've mentioned some of them. Forensic accounting is one. Of course, there are forensic accountants on island, but not necessarily with the experience that we require for the sort of investigations we're doing. And so even, of course, we have the major accounting firms all with large offices here in Cayman, and most of them would have that capability, but not necessarily with their personnel here in Cayman. It might be at an office elsewhere. So that is one of the areas. Increasingly, it is in the area of electronics that we need additional expertise. That's in terms of investigating electronic hardware like computers, cell phones, all of that. We don't really have that capability on island, and in fact, it is not widely available anywhere. We know where that expertise lies, but it's in a few places, and those few places are in demand. So it's not that we can't find it, but then we have to wait our turn to get that work done. And it's time-consuming work as well. And sometimes the evidence that we need that expertise to work on needs to, obviously these people need to have access to it. That in itself can present issues. You don't just put it in the post and send it. So it can have some significant issues. But, I mean, to go on from that, could we have people on island capable of doing that? Yes, I'm sure we could. Could we fully employ them? Highly unlikely, because we only need them from time to time. So it can be an issue, and it can cause delays, and it does cause delays. And we're always very mindful of that, particularly when a case is ongoing and people are already, in some cases, under arrest. but have not yet been charged and won't be charged until we have gone through the investigation to see what is appropriate. And of course, we're trying to get this done as quickly as we possibly can for the purposes of justice.
Thank you for that. Mr. Chairman, through you, when we look at the key messages of the Office of the Auditor General's report, pages 2 and 3, in the 4th paragraph, it states that the work of the Anti-Corruption Commission is reactive as it investigates allegations of corruption that are referred to it. Yesterday we heard evidence of this from the Deputy Governor, that the increase in reports to the Anti-Corruption Commission came as own investigations conducted internally by the government and then therefore suggested to the Anti-Corruption Commission, not the other way around. The Anti-Corruption Commission didn't go to the government and say, we have questions about so-and-so. So again, the body itself is more reactive, as you stated, rather than having the ability to issue its own reports. It says many corruption investigations are complex and can take a long time to complete. It is not clear whether the ACC has the resources it needs to effectively investigate the volume of existing corruption cases. It was investigating 14 cases at the time of the audit, some of which have been ongoing for a number of years. Notwithstanding your previous testimony, which identified that there's a growing demand for persons with your specific skill sets that sit on anti-corruption commissions, and those persons aren't widely available. Notwithstanding that, what in your estimation would be the ideal staff complement that would both enable the Anti-Corruption Commission to investigate and close cases in a more efficient manner, but also, be able to move or have the opportunity, like the Office of the Auditor General and other bodies, to be able to initiate your own investigations. So perhaps there are things that you see that no one else does. What would be an ideal number, if asked?
Thank you, through me, Mr. Chairman. Well, perhaps I can preface my answer by saying we can, of course, initiate our own investigations if we choose to do so. We don't have to wait for a report from outside to do it. But yes, the public service often does initiate a report to us that they find that they have a suspicion something has or is going wrong, and they refer it to the Anti-Corruption Commission. And I sort of call the Anti-Corruption Commission really the anti-corruption police in Cayman, because that's our role. We are a police service, but we specialize in anti-corruption. That's what we're there to do. We investigate, and then, as I've already said, we pass the matter to the DPP's office for them to make a decision on what charges should be laid and then carry it forward. And the DPP's office, as I'm sure you honourable members are fully aware, is extremely busy and has a very, very heavy caseload. We don't just liaise with the DPP at that stage when we pass it over, but we generally are liaising with them continually during an investigation to make sure that we are covering areas that they feel are necessary to a successful prosecution, and are not missing or not going down a route that will be non-productive as far as they're concerned. So we work very closely with them, and I'm not in any way blaming the DPP's office, but they themselves have to deal with things on a priority basis, and so that can sometimes, cause some delays. And it's just the way things are. I think certainly if we had more investigators, we could deal with more matters and not have to prioritize as much as we do. An ideal number, we could probably do with double what we have now. I mean, we have 6. If we had 12, it would be a lot better. because we don't just have one investigator on one matter. Sometimes some matters require a number of investigators to deal with them. And some of the cases are very complex, so they take a lot of manpower and a lot of time. So it's difficult to put a number on it, but if you ask me to, I would say, well, if we doubled the number of investigators, and as I've already mentioned, we have one trainee, Caymanian trainee, we would very much like to have a second one. So that would make a real difference, I think, to us.
Thank you. Mr. Chairman, just one final question, and I will be focusing on paragraphs 45 to 47, which are contained on pages 20 through 22 on the Auditor General's report. And if I can just preface it, Mr. Chairman, through you, certainly not to question the integrity of the testimony that has been given and provided to us today in any manner whatsoever, but if I could make a brief observation that it seems sort of the status quo, if you will, whenever we are dealing with matters of recommendations from the Office of the Auditor General on respective departments or agencies or commissions, the standard, and I use this term very loosely, and again, not to question the witness integrity specifically, but me making a general comment, that the standard status quo excuse is, well, we'd be able to do more if we had more resources, if we had more staff, if we had more investment in technology, et cetera, et cetera. And what this committee seeks to understand is which of those claims for the need for more resources is in fact a legitimate claim, or is it just, again, loosely speaking, a cop-out for lack of efficiencies within the operation of these respective departments, et cetera. And that is why I point to paragraphs 45 to 47. The paragraphs state that the ACC reports its performance publicly through its annual reports. Performance information could be improved by extending to it to include some efficiency and effectiveness measures, such as the cost per case, the length of time taken to investigate and close cases. Paragraph 46 on page 21 states that over the period of 2012 to 2017, the number of active cases varied from year to year, with the highest number in 2013 to 2014. But it is not clear how many live cases continue from one year to the next and how many are new cases. This to me identifies that there may not exist an active empirical measurement in which the Commission itself can measure its own effectiveness, its own efficiency as a Commission, as a body, and also this empirical evidence or measuring stick may better enable yourself, Mr. Chairman, to measure, well, is it 6 staff? Is it 12 staff? Or will 9 actually cut the mustard with some improved investment in technology? So the question is, first of all, would you agree with the Auditor General's recommendations that perhaps what is lacking from the Anti-Corruption Commission is a tool to measure effectiveness and efficiencies, and would you otherwise agree to adopt the recommendations put forward? And secondly, do you accept that this lack of measurement may also be a limiting factor in terms of the performance of the Anti-Corruption Commission, sir?
No, happy to answer that question. If I can put a bit more color around the sort of number that I gave you. In terms of an investigatory organization, the ACC is very young. In its present form, we started 2016, 2.5 years ago. Now, under its present guise, under its former guise, with the Commissioner of Police as the chairman, it effectively had the entire resources of the Royal Cayman Islands Police Service. And when the Commissioner wished to do so, he just pulled in officers from our SIPs to deal with cases. So I wouldn't say he had unlimited resources, but he had hundreds if he wanted to use them. of course, when it was completely reorganized and we had our own investigators, then we now have 6, a somewhat different number. So that of itself creates an issue. It's a totally different concept. And we are evolving, which is why I said that it's difficult to give you a number. Sometimes 12 would make a huge difference. Sometimes 30 or 40 would make a huge difference. But we don't have that capability that the Commissioner had, and we don't necessarily want that capability because we're an independent organization. That isn't to say that we don't get support from the Commissioner and ARCIPS, because we do when we want it, and we have the ability to delegate to the Commissioner in certain instances. And so, for example, when we do require additional manpower on a temporary basis, say when we are carrying out multiple search warrants, we do not have sufficient officers to carry out multiple search warrants all at the same time, which very often that's the way it is done. And if there is a female involved, we do not have a female investigator, so we need to call upon ARCIPS for a female officer to assist. So those are the sort of things that where we have to get additional assistance. Would we need all those officers all the time? No, we wouldn't. But the nearest I can tell you is, and I've discussed this with the investigators, that to double that number would make a material difference to us. In terms of sort of our reporting, we do the best we can in terms of giving the figures and so on. Of course, cases on indictment here in Cayman do not run on a time limit. We can pick up a case anytime and reinvestigate. It's not like the United States, where they get time barred and that's the end of it. So, to a certain extent, when we have a case that perhaps has, we've had to pause it for a while for whatever reason, that doesn't mean it's closed. If we get further information, either ourselves or from a member of the public, that case is reopened. And so it never really gets closed, and it remains there. And sometimes it can start to go live again, and then it can be put on hold again. You just never know with these things. So it's difficult to say that case is now closed, finished, we'll never deal with it again. That doesn't really happen in this jurisdiction. We're different to the United States. Otherwise, I would say, the Commission's talked about this. Could our record keeping be any, more useful in those terms? We don't do timesheets like the law firms do. We don't sort of have a timesheet and say we spent so many hours on this. We don't do it like that. The investigators, of course, make their notes on a file-by-file basis, which is how they have to do, because that's the file that gets passed to the DPP's office, and he has to see every single thing they've done. So to that extent, when an individual investigator does some work, the file is annotated as such. And then there are time records, but that's merely to say that an investigator has worked on various cases for a set number of hours in the day and fulfilled their commitments. We don't have the sort of, as I say, the timesheets the way that some of the professionals do. And I don't think that would work, because they're working on multiple cases all the time. And so that would be kind of hard. But I mean, we can certainly look at seeing if we can, have some method of using the buzzword value for money, see if we can make sure that we can, identify that, because certainly that's what we want to do. And the more statistics that we can, or useful statistics that we can have, I think the better it would be. So, I mean, we certainly value all these comments, but I'm just being honest with you how the system works. And it's, as I say, we've been going in our present form only for about 2.5 years. So we're still sort of moving from that, having the unlimited resources of ARCIPS, to the individuals that we have employed with the ACC.
Nothing further, Mr. Chairman, other than to certainly thank the witness again, and in particular to thank the members that make up the Anti-Corruption Commission, 6 doing the work of, 30, 40, 50, doing a commendable job. But certainly in the environment in which we operate in, it is a much needed service, and I just wanted to extend this committee's thanks.
Thank you.
Thank you, Mr. Chairman, and Mr. Coles, thanks very much. I just want to say that I really enjoyed reading this report because I found it to be very frank, very straightforward, and it wasn't sugar-coated, so I really appreciate it. One of the things I just want to bring up is on page 12 also, section 5.1.2, where it speaks about the Public Authorities Amendment Bill. And it says in the report, the Commission has concluded that it falls under the definition of statutory authority in the Public Authorities Law and should be included in the Amendment Bill, Section 3 and Section 5 for law enforcement as one of the listed functions where the bad faith rather than negligence standard applies. A request was made to the Attorney General, but this was not taken forward in the Amendment Bill when passed in the Legislative Assembly. Just a bit curious in terms of what is it, because if this is something that the Commission or your members feel that something is important, maybe this is something that maybe we need to revisit.
Yes, it was something that was discussed by the Commission, that the standard, if you like, which was then put in the amendment to the Public Authorities Law, applies to most of the boards in Cayman and to the Monetary Authority and so on, but for some reason the Anti-Corruption Commission was left off that, and when we saw that, we made a representation to have it included, but it wasn't included. So I think the same standard should be across the board, really, and I have no idea why it wasn't included. Maybe it was just an oversight, I don't know.
That is something that we can deal with. And that's pretty much my last question, and I guess this is more for a broader thing. We're in the very first one, when it speaks about proposed amendments to the anti-corruption law. It says legislation to permit investigators to use protective gear in the course of their duties was presented to the Legislative Assembly. I know that one was actually also approved. Yes. But it says, goes on to say, there are other desirable amendments to the law. Members will meet during the next reporting period in order to discuss and recommend any necessary future amendments to the law. Just out of curiosity, in terms of just trying to understand, like what additional legislation you think would be needed to the anti-corruption law in order to make it, I guess, more effective? Or have you guys had a discussion yet? Have you guys come to a conclusion, or?
We haven't come to a conclusion yet. We're going through that process. In fact, the last meeting we had some proposed amendments, put before us, and we were taking them away to look at them. But some of them arise from this transition from us in the past using our SIPS officers to now having our own dedicated officers. And so there are some powers that a police officer has that our investigators should also have that haven't been maybe effectively transferred. And so we would like to, correct that. I don't think there's anything contentious in there at all, and I think the intention was that all the powers that they would need would be transferred across. But there are occasions, and I probably wouldn't want to speak about them here, but there are occasions when we, in fact, have to use an RSIPS officer because he or she has the power that the investigators don't, and that clearly is not how it should be.
Thank you very much, Mr. Coles. I just want to say I think that what the ACC is doing, this is quite commendable. I noticed just looking at your stats, you, I think, arrested 12 people and charged 10, so that's actually a pretty strong number. And I believe that you do have one case that's going on next door in the courts right now. Yeah. So it's clearly that something is being done, and I just want to say on behalf of the members here that, well done to your team, and, please, pass on our gratitude from the members of the PSC, and I'm sure other wider members of the Legislative Assembly.
I will. Thank you very much.
Yes, sir. Thank you very much, Mr. Coles. We appreciate the time, and we ask you to continue to keep up the good work. So.
I will certainly try.
All right.
Thank you.
Yeah. All right. I'm very Trumpinian of, you know. And he, in all of us case, be careful what you ask for. So we'll adjourn the committee, and as soon as I get an indication of when Ms. Rose Whitaker can come, I'll circulate the around Robin to establish a date, and then we can add the person from planning for that same day. Okay, so the meeting is adjourned.